All right. Good afternoon, everyone. Thank you all for joining the next in our series of webinars related to the Second Amendment to the NYDFS 500 cybersecurity regulation. Today, we're going to be reviewing enforcement actions, their causes and consequences. A quick overview of our agenda. We're going to start off with some introductions, move on to a breakdown of the enforcement actions, our analysis of causes and consequences, finish off with some tips on avoiding and mitigating penalties, and end with a Q&A. On to some introductions. John, would you like to start?
Sure. Thank you, Miguel. Hi, everyone. My name is John Jarrold. I'm a security risk management consultant at WithSecure. My responsibilities include delivering cyber maturity assessments, cloud configuration reviews, secure design reviews, and all of the various security risk management service offerings that we have at WithSecure. Prior to joining WithSecure, I spent 15 years in financial services working in cybersecurity and risk management, and responsibilities included regulatory compliance and also the New York DFS regulation. Richard?
Thanks, John. My name is Richard Suls. I'm a senior security and risk management consultant at WithSecure, working out of the New York office. I'm service lead for our tabletops and crisis management exercises. Also regularly perform pen testing NetSec, maturity reviews, occasional incident response lead. And in my spare time, I work with the state and federal courts as an expert witness. And perhaps Miguel?
Hi, everyone. I'm Miguel Gutierrez, an SRM consultant here at WithSecure in our New York City office. My work here is primarily with design and architecture reviews. Prior to my time here at WithSecure, I worked as a security architect at a bank here in New York. So I've experience dealing with this and some of the many other regulations that apply to financial institutions, as well as designing systems and recommendations for compliance. A quick reminder to our viewers, if you have any questions, please submit them using the questions and comments box. We will have time for a Q&A at the end of the presentation. So to start off, let's go over some definitions. So what are enforcement actions? To start, these are the legal measures that NYDFS takes against covered entities. So that's going to be your banks, insurance providers, etc., that violate its regulations. So these exist under over a consent order, which is the legally binding agreement between your organization and NYDFS to resolve this matter of non-compliance without going to trial. This consent order is going to have a few details, and that includes the incident or deficiencies that led to this action, the specific sections of the regulation that have been violated. NYDFS is going to give you some remedial actions, some recommendations, and it's going to include that monetary penalty. Ouch. As well as on top of this, these records are all published on the NYDFS website. So there's, on top of the headaches mentioned above, there's also going to be some reputational risk as well. We'll start off with analysis of these enforcement actions. Richard, would you like to start?
Thanks, Miguel. So what you see here is that there have been 16 enforcement actions since the regulation was enacted. And now we're talking about the original regulation, not the amendment, which is going to come into effect soon. The average monetary penalty was almost $3 million, ranging from $1 million to $5 million, though there is an exception, which we'll talk about at a later slide. The security incidents related to these enforcement actions resulted in theft of almost $2 million. And as you can see from the slide, there's only one consent order so far in 2024. 11 of these actions were directly related to security incidents, and 5 were due to deficiencies discovered in exams. So what you might notice here is that there's a shift from enforcement actions resulting from a security incident, which was what was happening in the past, specifically in totality up until 2022. Now what we're seeing is that they're coming from failures of exams without a breach having to actually occur. So it's possible that this trend could result in additional enforcement actions as an indication that they're attempting to raise the bar. And just a reminder, these likely come from failing to address MRAs. They're not just the immediate result of an exam failure or a failure on an exam. And what we're seeing is that DFS appears to be more aggressive in issuing penalties for non-compliance discovered in an exam in these last 2 and now 3 years. So details of these security events are found on the next slide, and I found one very interesting. So in the top right corner, you'll notice December 2018 web vulnerability. And this left more than 850 million documents publicly exposed for multiple years. The covered entity failed to implement sufficient access controls to prevent unauthorized access to this NPI. There was a vulnerability in one of their systems which allowed unauthorized access to sensitive documents without authentication. The issue was not addressed promptly, despite being discovered internally. So what happened? The covered entity identified the vulnerability months before it was publicly reported in December of 2018, but they failed to take appropriate action until a journalist exposed the issue in May of 2019. They were imposed a $1 million fine for this as part of their settlement, and they implemented significant enhancements to their cybersecurity practices, which is why we see a $1 million penalty, which, as you may note from what I mentioned prior, is $2 million less than the average penalty that we saw over the last few years. And the event obviously demonstrates the importance of timely vulnerability remediation, strong access controls, and continuous risk assessments to avoid these types of enforcement actions. Miguel, I know that you had analyzed these as well. Is there anything you'd like to call out that you found interesting?
So a few months after the story was published, we have this other event in September of 2019. A phishing attack led to a user's email credentials being stolen, username and password. And this was pretty directly just led to a business email compromise. The attacker impersonated a broker and initiated a $35,000 funds transfer. I think it's a story we see often, phishing attacks, and I think this is something that we'll touch on this a bit later, but something that MFA may have been able to stop. John, you had a couple you'd like to get into as well?
Yeah, thanks, Miguel. The July 2017, so that massive breach there is actually Equifax, which is very well publicized. The interesting point here is that Equifax is not a DFS covered entity, but DFS went after them anyway because of the number of New Yorkers who were impacted by that event. Another one, September 2018. This was a incident where the attacker compromised employee credentials through a phishing attack. The entity did have MFA in place. However, the attacker was able to bypass it because the entity had also implemented an IP allow list to go around MFA for service accounts, that non-human accounts that couldn't use MFA. And apparently the way this allow list was defined was very broad, and the attacker was able to originate an attack from an IP that was included in the allow list and get around that. Another one in March 2019, again, the entity had MFA in place, but in this case, the attacker was able to bypass it through a more simple method of what's called MFA fatigue. So they just continuously and repeatedly sent push notifications to the employee whose account they had compromised until the employee finally relented and um, authorized the access, and the threat actor was able to get in. So, in this context, DFS is mentioning security awareness training, that users should be aware of this type of a threat, and not fall victim to that.
Thanks, John. And so we'll move on to the next slide, where we've taken these events and conducted our own analysis by attack vector and impact here on the right. One thing to note, so looking at the attack vector side, no surprise here that phishing is the most common attack vector that we've observed in these cybersecurity events. It's nothing really new to us, security professionals. We are aware that humans are the weakest link in any system, really. And it's really just a matter of time before one of your users clicks that link. Related to the event I discussed in the last slide, with the theft of user credentials, we see that DFS is pushing for more stringent MFA requirements, and the text that they use in the regulation is this requirement is for any user on any system. For those of you who weren't with us on the last webinar, I did reach out to DFS to ask for clarification on this requirement, and I think the important point to note from their response is that the MFA requirement applies to the user authentication stage, and not necessarily to any federated access that happens after that. I think if you look at a really common use case, workstation in Office, it's, in my opinion, likely very important to have MFA at that initial access point to your internal systems, where then you can federate access to other applications and not have eventually what amounts to MFA fatigue, like John had discussed earlier. For those of you that run an Azure shop, some good news for you. Microsoft is going to be requiring MFA for Azure by default next month, October 15th. So that might make your job a little easier, but just kind of speaks to the importance of MFA. Everyone's implementing it, and DFS is going to require you to do so as well. John, did you have some words on the impact?
Sure, thank you. So you'll notice the most common impact that was mentioned in the consent orders is NPI exposure. And this is resulting from attackers gaining access to compromising an employee's account, and then they're able to access whatever NPI that employee had access to. You'll also notice on the right-hand side that there were 3 instances of ransomware attacks that were mentioned. One related to an attacker who, through a phishing attack, compromised the account of a network administrator and was able to steal their security certificate, and likely gaining significant privileged access through that, which they used to extract data and then launch the ransomware attack. Another ransomware attack was Carnival Cruise Lines, which is fairly well publicized. What may not be as well known is that Carnival Cruise Lines is licensed by DFS to sell life insurance. So this ended up being, that attack ended up being under the remit of DFS, and they issued a fine to Carnival. If you go to the next page, we talk about the violations. So here the consent orders mention specifically what sections of the regulation there were violations. What we found is that across these consent orders, there were violations of every single section of the regulation. Two of the big areas you'll see at the top is the cybersecurity program. So these violations stem from either the covered entity not having a cybersecurity program, or there were instances where there was a security program but the entity had not done a risk assessment or hadn't done an adequate risk assessment. So essentially, DFS found that that security program was not effective because it wasn't being based on a risk assessment. The next one around policy. So these violations came from either, again, entities not having any policies defined, or there were also instances where DFS pointed to the particular policy that was related to whatever incident occurred and found that, that policy was ineffective or inadequate based on there having been a breach in that area. One consent order that I found interesting here is there was an entity that had a whole set of security policies. However, they hadn't done a risk assessment. So DFS found that essentially all those policies were null and void because the policies had not been based on a risk assessment. So this really highlights the importance of risk assessment in the context of, well, in general, but in the context of the DFS regulation, risk assessment is really important because it can, have impacts in all the other sections around, how well the risk assessment is done. Yeah, so Richard, you want to talk about some of the other areas?
Thanks, John. Sure. Yeah. So what I wanted to call out, among other things, is that the CISO column has 5 violations. One of them is specifically for not having a CISO, and the other 4 are for not providing an annual report to the board of directors. And further, we see down and under 500.12, our friend multi-factor authentication rears its head again. There were 8 violations for lack of multi-factor authentication. And I think that, keeping in mind these are previous violations prior to the Second Amendment taking effect, I think we're going to see a lot more interesting spread of numbers in the next year or two. Miguel?
I wanted to talk about these last 2 rows here relating to notices to superintendent, where we've got a total of 19 violations. I'll start off with the first one, notice of cybersecurity event with 5 violations. This relates to the particulars that NYDFS sets out for notifying them in the case of a cybersecurity event. And that's going to be, within 72 hours, and that's going to be to them specifically. So it doesn't matter if you've notified law enforcement or the FBI, you need to tell NYDFS specifically of this event in time. And lastly here, this is what I find the most curious, the annual statement of compliance. So when you submit your attestation of compliance to these requirements and your CEO signs off on it, you think you're okay until an event occurs. And from NYDFS's investigation, they find that actually there was something that was misconfigured or something that wasn't implemented up to spec of regulation in their interpretation. So, they can go back and say, on top of whatever violations caused this incident, we'll also tack on that your statement of compliance that you falsely certified this compliance. So this is kind of a free space on the bingo card. It gets tacked on as much as it can, and it's really no fun. I think we can move on now to everyone's favorite part here, which is the monetary penalties. I think, Richard, you were going to start.
Sure, thanks. So what I'm discussing here is the $5 million penalty in 2022. This came about from Carnival Cruise Lines, which you heard John mention a little bit earlier. They had 4 major breaches from 2019 to 2021, including phishing and ransomware attacks, which exposed sensitive NPI, including passport numbers and health information. Carnival failed to implement mandatory MFA, and they delayed reporting the incidents as required under the DFS amendment. Ultimately, as a result, they were fined $5 million and forced to surrender their New York insurance licenses. Miguel, would you like to discuss another penalty on this chart?
Sure. I'll be taking that $4.25 million penalty in 2023. This one I found quite interesting because this wasn't a result of any one particular security incident, one that occurred in 2023. This was a result of multiple incidents that occurred, years prior with third parties. So I think a couple of the incidents where there was a debit card processor contracted by the organization that gave another customer unauthorized access to this organization's NPI. There was a hacker that accessed the email systems of a law firm contracted by this organization. And ultimately, what DFS found in violation of these regulations were that their due diligence for their third-party onboarding was not up to spec if they weren't able to capture the flaws that led to these events at third party. And also, after these events had occurred, this organization just cut off their relationship with these vendors and didn't really perform any revamp of their due diligence processes or update, say, like their risk register with an updated risk rating of these vendors. So there's no really organizational change that would prevent this in the future. That's kind of what led to this large fine. I did get a question here about how can smaller organizations with limited resources comply with NYDFS regulations? And I think that might be something that John can take on in his piece. He's going to talk about this small penalty here.
Sure. Thanks, Miguel. So yeah, you'll notice this outlier in 2021, a penalty of $150,000. And what was mentioned in that consent order is that in assessing the penalty, the DFS took into account the size and revenues of the entity. And we'll see this more in the next slide, that with the Second Amendment, the DFS included a section explaining the criteria that they use for assessing penalties. And so that was the reason for that small penalty, that there was a small organization and they took that into account. I also want to mention on the right here these huge penalties that aren't included in the chart. And the reason is that these were enforcement actions that related not just to cybersecurity, but to violations of other DFS regulations, most commonly anti-money laundering. So they would resulted in these huge penalties. We'll just go through these kind of quickly. The first one, 2018, was Equifax, which we talked about before. The next one in 2022, this was interesting because in this scenario, the covered entity was relying on the cybersecurity program of their parent affiliate. And this is allowed through the regulation. You can rely on the program of an affiliate. However, what the DFS found here is that the parent's affiliate program really wasn't adapted or specific to the covered entity. And they pointed out there was no risk assessment done at the covered entity level. There was no reporting to the board of the covered entity on cybersecurity. There was no disaster recovery plan for the covered entity. So they found that reliance really didn't qualify. So that's just a point of note and warning that if, although it is allowed to use the program of a affiliate, it needs to be specifically adapted to your organization. Next big penalty here in 2023. So this one was for a cryptocurrency organization. The finding here around their Know Your Customer program. DFS said essentially it was a check the box exercise. They weren't doing any adequate level of due diligence around KYC. And then from the cybersecurity side, they found that there had been a unreported security incident, and this was interesting. It involved a attacker who was able to compromise the accounts of 6,000 of the uh, customers. The entity did have MFA in place, but there was a flaw in the way they had implemented the account recovery process. So the attacker was able to exploit that flaw and essentially bypass MFA for these users whose accounts they had compromised, and they ended up stealing. I don't remember the exact figure, but it was in the millions of dollars that they ended up stealing from those customers. And then the last one there in 2024, this was another cryptocurrency firm. They was cited for having inadequate anti-money laundering, and also on the cybersecurity side, not having an adequate risk assessment. And this enforcement action actually ended up with the covered entity needing to surrender their banking license, and they ended up filing for bankruptcy. So, huge impact from that particular action earlier this year. You want to go on the next page, Miguel? We can talk about the. Um, okay, so one thing that we wanted to point out, and you're probably aware, is in the Second Amendment of the cybersecurity regulation that was enacted at the end of last year. DFS added a new section where they explicitly mentioned the factors for assessing penalties, and we definitely recommend reviewing and understanding this section, because it could, if an organization was assessed a penalty, this could potentially mitigate the amount of the penalty. I won't go through these in detail, but just wanted to call out kind of some themes that we saw in this list. So the first one is behavioral. So things like, did the entity cooperate with DFS? Did they act in good faith? Did they what was their involvement from the senior governing body in a positive manner, and was there any false or misleading information that was provided, would all impact the level of the assessed penalty. A second theme is sort of contextual. So these are things like whether the event was or the deficiency was unintentional or inadvertent, or based on reckless negligence. If there was a failure to remedy previous findings from previous exams led to the issue. Looking at, did the entity have a history of prior violations? Looking at whether this was an isolated incident or repeat violation or systemic failures. And also taking into account of whether there was any sanctions imposed by another regulatory agency. And then last sort of key theme is just around the severity of the impact. So looking at, what was the harm to customers, what was the gravity of violations, the number of violations, and the length of time that in which they occurred. So they'll take that sort of severity factor into account when they're assessing penalties. And then you'll also notice number 14, financial resources and net worth. We mentioned this earlier around that small penalty that was assessed to a smaller organization, so that they're noting that is one of the factors they'll take into account.
Thanks, John. I think now we can move on to our Q&A. So I've got a list of questions here that have been submitted during the presentation. Let's see. I think we can start with the first one we got, which is, how did you go about analyzing the NYDFS consent orders?
I can take that one. So, so the consent orders are public record. They're PDF files that are on the DFS website. We downloaded all of those, and that was over 250 pages of documentation. We used Excel and some other analytics techniques to kind of help to automatically extract things like the sections that were violated to get some of these metrics. But a lot of it was also just manually reading through the consent orders and understanding what had happened. So, like for example, the summaries that we provided earlier of what events occurred was all just going through and reading and understanding. And they do make interesting reading. Hopefully, some of the stuff we've mentioned today was valuable or gave you some insights. But certainly, yeah, maybe worth looking through.
Thanks, John. The next one we have up here are there any more anticipated changes or updates to the NYDFS cybersecurity regulations? And how can organizations stay ahead of potential regulatory changes?
I can take that one also. So the DFS just announced the Second Amendment, enacted the Second Amendment to the cybersecurity regulation in November last year. Their justification or rationale for doing that was to address the root causes of some of the security events that they're continuing to see, and just the evolving threat landscape. So one of the changes, Miguel mentioned earlier, is the requirement to have basically MFA everywhere. Any user accessing any system needs to be going through MFA, and that's intended to address, the prevalence of these phishing attacks that were successful because the entity either didn't have MFA in place or hadn't impacted or hadn't implemented it effectively. The Second Amendment will go into effect in like the first initial regulation. There's transitional periods, and I think Miguel, you looked at this one. It's out through 2025. I believe that the end of 2025 that all the sections of the Second Amendment go into effect. And then just with regard to being able to stay up to date with regulatory changes for the DFS, there's a mailing list that you can sign up for, and they will send you updates. You can keep an eye on their website. We've also found that DFS is fairly good at responding to queries. We've sent them, as Miguel mentioned earlier, we've sent them queries about clarification on certain provisions, and they're pretty good about getting back to us with good, clear responses. And then, more broadly, it's always a challenge keeping up with all of the regulatory activity, but, just needing to ensure that you do have processes in place to keep track of changes to cybersecurity regulations across the board. And there are resources that can help you do that.
Thank you, John. Well, it seems like we're getting quite a few more questions now. I do want to be conscious of time. It seems that we're running about 5 minutes past. I think we do have time for perhaps one more question. I see. We were actually booked for the whole hour, so we're good. Okay, so let's move on to the next participant question we have here. So what role does employee training and awareness play in minimizing the risk of enforcement actions? I do know that with this upcoming regulation amendment, there were a couple of changes made on the requirements for employee training and awareness. So apart from anything more abstract, I think there's a concrete connection between having this awareness program in place and what topics that program covers. that DFS does require of your organization. I think specifically it was to include phishing training has to be a part of your security awareness training.
Yeah. In the initial draft, they were going to require phishing simulations, and they backed that out in the final version of the regulation. But that's definitely advisable to even though it's not required by the regulation, to run those phishing simulations to provide training moments to employees in a real life scenario that they can learn from.
Thanks, John. I think down the list, here's an interesting one actually. What are the best practices for incident reporting and communication with NYDFS?
So on this one, I can say, make sure you report to DFS in a time within the 72-hour period. There was one consent order that mentioned that the covered entities incident response plan did not include a step for notifying DFS. So make sure that your incident response plan specifically calls out that that step to notify DFS. And then I'll just mention a couple interesting developments in the Second Amendment that well, I guess just one main one is that the DFS is now requiring for covered entities to provide to report if they've made a ransomware payment, and then after some period, 30 days or so after, to provide a written justification for why they made the payment. And what they've said is that they're looking to gain a better understanding around how ransomware is impacting covered entities, and wanting to understand what the thought process was around deciding to submit to that payment, so that they can look at are there other ways that they can help mitigate the effects of ransomware just by getting more insights into what's actually happening.
And I think this can be a follow question to this, because we just got another Q&A that I think follows a similar thread. And that's, how does a company meet the short notification timelines when a forensic investigation can take weeks?
Yeah, that's a really good question, and I know the organizations I've worked with, not that they experienced any breaches, but this was a discussion point of how much information do you provide, given that it's a developing situation. Not specific to DFS, but with other regulators, I think I've heard that there's an understanding that the covered entities are not wanting to go into a significant amount of detail. I think there's provisions in the DFS itself around, in the Second Amendment, they talked about that, trying to think of how this was laid out, that there was in the original draft of the Second Amendment, they were asking that covered entities provide, full details around all the telemetry and so on around the incident. And then there was pushback in the comment period that this is highly sensitive information and not something that they would necessarily want even DFS having. DFS pushback saying, we have effective security controls in place to prevent that information getting exposed, but they ended up walking that back. But I guess no real, good answer about how do you meet how do you? I think organizations do struggle with that. Is what level of detail should you report? I think this can be an interactive discussion. You can start with a sort of a high level summary. Expect that there's going to be a conversation that takes place after that with the DFS, and if they're looking for additional details, it can be discussed. And I wouldn't expect that they would ding you on not providing enough detail in your first pass, so you can come to agreement on what's the right level of detail to officially report in just actual live discussions with the regulator.
There was a question regarding email being a valid second factor for DFS requirements. And I'm going to start by saying that typically email is considered a valid second factor authentication. However, I would also state that DFS does not typically in these lay out specific, you must do MFA this way or you must do MFA that way. So when it comes to something like that, you may want to reach out to them for clarification. In a general sense, though, email is considered a valid second factor authentication.
Thanks, Richard. Let's see. What other questions have we got? So here's one. During our assessments, based on NYDFS requirements for IRPs, what are the most common gaps that have been found? I think that was something that we may have covered in the violation by section, maybe at a high level.
Yeah, maybe you can go back to that violations by section. I think there was only one or maybe two violations of the incident response plan. It's kind of two of them. Okay, I can only remember one, and this was that the incident response, I mentioned this earlier, that the incident response plan did not include a step to notify the DFS. And then I think I don't want to say for sure, but I think the other one related to that the response to the incident wasn't very effective, and they attributed that to the incident response plan not having significant detail. Although this also might be related to that consent order we mentioned, that the covered entity was relying on their program of their parent affiliate. And I remember they definitely mentioned that there was no DR plan. That might have been that the incident response plan in that case was also not specific enough to the covered entity. But in general, that we haven't seen a lot of that. That hasn't been a common finding of gaps in the incident response plan.
And there's a follow-up question that follows the same thread as well. So looking into like that one or two consent order, or one of those consent orders, did any of them include any insights into like delays in response caused by a poor IRP? A specific cause, like a lack of identified out of band comms, or did they go into that level of detail?
Meaning that the incident wasn't reported because it wasn't detected timely, or
rather that maybe the IRP doesn't include out of band communications, that hasn't been set up in the case of an incident, and maybe that led to a delay. I think that's what this question is asking.
Okay. Yeah, the factors I remember with regard to, and this would be under that, what is that, 517A notice of cybersecurity event, is that it required to notify within 72 hours, and they did not. One interesting point here was that they mentioned that the entity had reported the incident to other regulators, but failed to report to the DFS. And another interesting case here is that the DFS discovered there'd been an incident during an exam. So they came in to do an exam, and as they were going through their findings or their request for information, they discovered that there had been an incident, and they said, well, did you report this? No, we didn't. So that ended up with a violation for that. But I don't recall anything around the out of bound communications, or it was just not recognizing, mainly it was just not recognizing that there's that requirement to report the incident to DFS rather than the process for reporting itself.
Okay.
There's been a clarification about that question posted. What, if any, causes were identified for delayed response remediation? Comms were just an example, not the notification per se, but the overall response remediation effort.
I don't recall anything specific to that in any of the consent orders.
Yeah, I believe, and John, you are by far the subject matter expert, so correct me if I'm wrong, but I believe the understanding is that you are meant to go to the DFS portal and register the cybersecurity incident within 72 hours, but that just gets the conversation going. At that point, DFS may not expect you to provide them with 100% of the information. They may not expect you to have 100% of the information, but you're going to be required to fill in those gaps further on down the road as the incident is remediated.
We have 2 additional questions that we can get into. I think the first one here is, so just a clarification on the incidents reported slide here. Where, it's me.
I'll bring us to that.
Yeah, thank you. Sorry, I'm just having a
You're welcome.
bit of trouble with my browser. On this incidents reported slide, so are all of these incidents that led to an enforcement action?
Yeah, yes, all of these, everything here. And if you go to the slide previous, so this page is providing a summary of the incidents that were described in the enforcement actions. So some of the enforcement actions describe multiple incidents, which we've captured here as well. I think 3 and even 4 incidents. Richard mentioned Carnival in particular. There were a number of different events that were mentioned. But yes, all of the incidents we talked about today were mentioned and related to enforcement actions.
All right. And now the last question that we have, I think before we can wrap up. So what best practices can financial institutions adopt to avoid triggering enforcement actions under NYDFS 500? I think apart from compliance, I think this question might just get into either how do you avoid a cybersecurity incident or how do you avoid an audit from the NYDFS?
Yeah, and this is interesting because this is actually a question we discussed in preparing for the webinar. That how do we avoid incidents? And what we kept coming back to is comply with the regulation and don't get a security breach. So we originally had a slide that we took out that went into horrible granular detail about all the different sections. We've done other webinars before talking about compliance with specific areas, but it's really that it comes down to do an internal assessment of your compliance with the regulation. Bear in mind that there's a new option in the Second Amendment that you can identify or you can self-attest to non-compliance so long as you're providing a plan and timeline for remediation. So if you have known gaps, it's recommended that you disclose those so that they're not, discovered by DFS and could lead to an enforcement action. I guess the other recommendation here would just be keep an eye and do assessments against the new requirements in the Second Amendment, because, like Richard mentioned, DFS is significantly raising the bar in certain areas. There's time allotted in these transitional periods to implement these controls, but you certainly want to get out ahead of that, make sure that you're on track to implement the new requirements and that you've assessed that you're meeting those requirements effectively.
So I believe that is the last question we received from the audience. I want to thank you all, the audience, for joining and for your thoughtful questions. Richard, John, thank you as well.
Thank you, Miguel. Stay tuned. We'll probably do another one of these. I believe this is the 4th DFS webinar that we've done. And as more information comes out and there's more to share, we will hold another one. Thank you very much for attending.
Thank you.
Thank you.